Hello, welcome to another episode of Justice for Y'all. I'm Paul Painter, and with me, as always, is Andrew Bowen and Stephen Morrison. How you doing, guys?
Better today. Well, I was doing well yesterday, but today I got some rest.
Yeah.
I'm doing fine. Been a while since we've done one of these.
It has been. It has been. Before we get into it, we want to thank the Creative Q in Victoria there, who is the producer of our podcast, and she was awesome and sent us these Yeti cups. If you can watch it on YouTube, you can see. And it says the Creative Coast for Bowen Painter trial lawyers. So thank you very much. This is a great gift, and it'll be well used, especially on the boat this summer.
Well, and Creative Q does a great job, not only with the podcast, but with a lot of our other marketing social media.
It does all our social media, our email mailings.
Yeah, a lot of graphics. Yeah, the email newsletter that's starting to go out. They do a good job.
They do a great job. Been really, really happy with them. Anybody who needs social media help, I mean, not trial lawyers in this area, but anybody else, call the Creative Q. They're wonderful.
Yeah, we got them locked down here.
Right.
Sorry.
You're tuned into the podcast where justice meets Southern hospitality. Broadcasting directly from Savannah, Georgia, join your hosts, Paul, Stephen, and Andrew of Bowen Painter Trial Lawyers as they chat about the legal difficulties you might face in everyday life. From the ports of Savannah to the busy highways that stretch through the southeast, we're your go-to source for all things legal. Served up with a dose of Southern charm and commitment to justice for y'all.
Sorry.
So, guys, we got some big news.
Yeah.
So
Something did happen.
Yeah, something did happen. You and Stephen and Paul, y'all went to trial.
We did.
Tell us about it. What happened? First tell us what happened, and then let's talk about the case.
You want the result? Is that what
Yeah,
you're asking for?
the result.
Well, we got a verdict yesterday for $700,000 in Chatham County State Court against the City of Savannah for a lady who tripped and fell on a defective curb and developed a permanent injury that affected her. This case was 10 years old, and we'll get into that in a second.
A little over 10 years. It was
Over 10
October 18th, 2014.
That's right. And she got hurt, and it turned into a permanent injury. She'll be suffering for it forever. And we finally got to trial and was able to try the case for her and got a result. So
The 3-day trial, two days of evidence, and then we came back to closing arguments yesterday morning. And that took till about lunchtime. Mm-hmm. Jury went out, had lunch, came back, got their jury charges. So the judge told them what the law was, and then deliberated for a good long time.
Yeah, 3.5 hours.
Yeah.
Yeah.
Which is, it felt like a very long time.
Well, I'll tell you, for those listening who aren't lawyers, and you hear all these things about juries, it's our philosophy that juries generally get it right, and you 3.5 hours. These 4 strangers sat in a hot room.
12 strangers.
I'm sorry, these 12 strangers sat in a hot room, and we could kind of hear them laughing, but also getting heated sometimes. Really discussing it and getting into this to try to come up with a unanimous verdict, which is really commendable because, they're getting paid like $30 a day. They do it for pure service. So we appreciate them and everybody who shows up and takes their jury duty seriously.
Yeah, Paul, you do a good job. And we got the very first part of the trial that we have to do is jury selection. So they bring in, ultimately you're trying to get down to 12 with 1 or 2 extras. But you start with a group of 40 or more people who come in. They got the jury summons, and nobody really wants to be there. But you spend a couple hours with them going through and asking them questions and trying to understand, first of all, are you qualified? Do you meet the minimum qualifications? But then are there other reasons you shouldn't serve on the jury? But you start that process by talking about the service that they're doing. And you get to the points I really appreciate that you make about it is there's 2 different ways to serve your country. And tell a little bit about how jury service is one of those.
Yeah, well, the 2 ways that most Americans can serve their country is join the military or doing jury duty.
And the only one they still have the draft for is jury duty.
That's true. That's true. And and with both those things, if you do them, requires great responsibility, especially in things you're not used to doing. And it is a real service to come in there and do that. So they took their job seriously, as I think most jurors do.
Yeah, that's the cool part. It's you don't know exactly what's going on in there, but it became very apparent that they were paying attention, even during the trial too. I mean, there's some
Oh, yeah.
testimony that can be a little bit of a snooze fest,
Right.
and especially when you get into some of the medical stuff, which is important and critical. We represent the plaintiff, so we have what they call the burden of proof. We are the ones that have to prove by preponderance of evidence, meaning more likely than not, what we say happened is what happened, that the defendant did something, it was wrong, it violated the law, that caused injuries to our client, and we had to go through the injury part, especially this case, when you got 10 years since it happened. And then you've got a lady who had other medical conditions, which we had to deal with because the jury and law requires that she's only entitled to recover for the injuries that are connected to the accident. And she had other things going on before that weren't affected by the accident. She can't recover for those. If things happen after the accident, which they do, especially with, a person getting a little bit older in age, they can't recover for that. So we had to walk them through and explain, okay, folks, what's connected, what's not. But it took some you got to do it with doctors. And
Well, let's get into the facts of what happened.
Sure.
Go back to, like you said, October 18th, 2014. Our client was, at the time, she was 52, and she was going with her cousin's husband to an all-you-can-eat seafood dinner at the Masonic Lodge over on East Bay Street. And this is 600
East
blocks.
Broad Street.
Sorry.
Trial was
Folks, you don't sleep a lot during trial, and I'm not my sharpest today, so keep correcting me, Stephen. So she, now this is kind of about even with the park, I guess, and that area. It's right by St. James African Church, and you get the Masonic Lodge. It's technically in the historic district, but definitely outside the tourist area.
Yeah.
I think it's a fair way to say it.
Which is why I wanted to make sure you didn't say it was on Bay Street.
Yes, yeah. Well, we got Bay Street comes in another part. But anyway, so she goes there, and it's a crowded event, and all the people are parking on the street. And so they go up, and there's a parking lot that was full. So the cousin goes to drop her off and drops her off where the curb is painted yellow. And by city ordinance, that's no parking except to load and unload. And so they go up, they drop her off, and as she gets out, she gets out of the car like anybody would, gets out, steps backwards to shut the door, and this curb, an oak tree root, had been pushing this curb out for at least 7 years. We have photographic evidence it had been coming out for at least 7 years, and was sticking, a good bit into the roadway where, and the curb wasn't in line, and she hit her heel and fell down, tripped on it, and fell on her right side. And in the fall, she she had a tear, a split tear in the tendon of her right foot, and fell on her shoulder and also hit her head, which ended up causing her some vertigo. So she gets up kind of stunned and adrenaline running. She goes inside to sit down, eats her seafood, and goes home. Next morning, the pain's really hitting, and she starts her medical journey at that point. I'll briefly go. So this case is 10 years old, and that's really old for a case to go to trial, especially if it hasn't previously been to an appellate court, and this one hasn't. And the reason for that is kind of threefold. The defendant filed in the course of this case 2 summary judgments, which is basically said, based on the facts of the case, the law doesn't allow the plaintiff to recover, and we won both of those. But also there was COVID, which delayed the case, as it delayed all cases. But this was obviously a really old case. But over the course of that,
And there was a change in attorneys. We didn't get involved in the case until 2 years ago.
2 years ago,
So another attorney had it for 8 of those years.
There's 2 judges too.
well, there was three plaintiff attorneys. One had it for a few years, gave it to another attorney, and then we wound up having it towards the end.
Right.
Yeah, 2 judges. So it was a whole journey to get here. But so what wound up happening very briefly is she was, this is part of the complication, but she was already seeing a foot doctor, a podiatrist for her pain, Brian Fallon, and she had some plantar fasciitis, and she goes in there. He recognizes she's got a new injury, winds up doing surgery, repair the tear. In doing so, a common occurrence of the surgery, a known complication, is that can cause some nerve entrapment, which is a pinched nerve, because they got to move the nerve to get to where he had to sew up the tendon, and that happened, and she wound up having this nerve pain in her leg and ankle for the next 4 years. Then he went back in and did surgery to relieve the nerve pain, but by then the nerve was damaged and didn't fully heal, and so she continued to be in pain. And also through this, she's wearing like a walking boot and that kind of stuff, and because of that walking boot, her hips were uneven, and that caused her back to flare up. Now, she had already had a fusion in her lower back, and she was seeing a pain doctor for other back pain that she had. She worked at Kroger for 30 years, staying on her feet. So, I mean, this is a complicated medical case where it's very unusual. I've never seen a case before where the trip and fall was on a curb going from a street to a curb, and there wasn't a sidewalk on the other side.
There's a tree lawn between.
Yeah, not perfectly
Right.
a lot. Yeah, there's a 3, 4 foot, 5 foot gap till the sidewalk. And then a person who was already treating for the foot and the back, which were essentially her ultimate injuries. So let's talk about.
Yeah. So y'all tried the case together and did a great job. So I want to, just as a preface to this question, or these questions I want to ask you, to make a recovery in a case, like you guys get a verdict like you did, you have to prove liability,
Right.
and you also have to prove your damages. So I want to ask you all first, in this case that you just described what happened, what was the biggest challenge you had to overcome for proving liability?
I think the biggest challenge is proving that this area is a known walkway, because the responsibility, what the law puts on the city, is they have to keep their sidewalks, curbs, and streets in good repair for normal modes of travel. And that was kind of the big thing. What is a normal mode of travel?
And the time of day ends up mattering too.
Oh yeah, of course. This happened at night, so she couldn't see it. I mean, that was a big
Right.
factor I didn't mention. So it's 9 o'clock at night. There's no moon out. There's no street lights in this area. So I mean, it was pitch dark. And so that was the biggest thing of, this curb sticking out, but it's not natural. I don't think most people would look at it and think, oh yeah, people are going to be walking there and can see it. So what we had to show, and we wound up doing this through the city employees actually, is they expect people to unload in these yellow curb areas, and they expect them to walk between the car and the curb. That is a known walkway that they anticipate people to walk on, and because of that, these hazards of something sticking out in the road are safety hazards. But that was a big thing, because most of the time it trips on sidewalks or curb cutouts, that kind of stuff. More traditional walking areas that most people think of.
And is that something that the defense was focused on as far as liability? Were they trying to tell the juries, like, look, this isn't a place where people are supposed to be walking?
100%. That was their defense, is we have no response. The curb's only supposed to keep in dirt and keep water flowing. That's all it has to do. That's what this one was doing. It's not a pretty curb, but this isn't our job, is basically what they were saying.
Yeah, and one of the other tricks here is Savannah is a 300-year-old city, and there were, understandably, this came out beginning in voir dire about when we have all the jurors there, we're trying to select the ultimate jury that sits and hears the case. This is an old city. Mm-hmm. You can expect broken, irregular curbs, and that was a concern on the liability piece, because it would be easy to frame this as a case where, well, you just want to tear up all the old parts, and this is an old city, so why should you do that? And the defense brought up, basically you'd have to kill the tree. So we had to spend the time to explain, number one, that's not what we're saying. We don't want to kill the tree. We know it's an old city. We like that it's an old city. But I think that the tide really turned on liability, and Paul talked about calling in the city employees, and we were able to prove the case without our only real witness was our client. Mm-hmm. But we called the former city employee, 2 former city employees, and then cross-examined the risk manager, who the city ended up putting up as their witness, about the city's policies, about safety in the city. And it started off by them admitting this important point Paul's talking about. This is actually a walking area. Sure, it's no parking. Sure, it's a curb. But the city knows and does expect that people are unloading and loading there. But it really came down to this when you took a look at the curb, and Paul did this really well with the city manager, or city risk manager. He pulled up photos of curbs in other parts of the town that were not East Broad here, where the AME Church are and this Prince Hall Masonic Lodge near City Hall. Big oak tree, sidewalk,
Historic.
nice, historic,
Yeah, that's
older.
Bay Street.
Yeah, that's Bay Street. Older, curb is in line, oak tree's just fine. Pulled up hotels downtown. The contrast between these tourist areas and this other part of town where the residents are, especially on East Broad Street. I mean, this part of town, kind of the outside fringes. It's not Jones Street, which is another, it's touristy, but it's also where kind of the hoity-toity rich residents live. I mean, this is just kind of one of the few areas, and they're both on the fringes of the community on East Broad Street and West Broad, which is now MLK. Mm-hmm. And that contrast was really powerful.
Well, at closing, I put up the pictures of this is what it looked like, to unload at the Masonic Hall in St. James African Church, and this is what it looks like to unload at, the DoubleTree Hotel. And it's like, and I don't think the city sort of saw this coming, because after my cross-examination of the risk manager, the first question the defense lawyer asked is said, well, on this East Broad Street, there's no hotel there, is there? And it's like, what? you really say that?
That's our point.
Yes.
So you for lack of a better word, one of the themes of your case here for liability was that there are two cities in Savannah. There's the pristine historic district that has all the tourists and is kept in immaculate repair, and then there are some fringe areas of the city that are maybe a little bit more derelict that the city ignores.
I think it was even broader than that. That's what I told the jury. There are two Savannahs. And there's the downtown area where the tourists come, and that is kept up pristinely and has these beautiful areas to walk on and make sure that none of those folks get hurt. But for the citizens, they don't care. They just don't care. Not the same way they care for that. There are two different standards in this city. And, they say there's no policies on there, but it was clear showing those photographed that there is an unwritten policy to take care of the tourists and not the residents.
Mm-hmm. And they can figure out how to make a curb nice with an oak tree beside it in some parts of town.
Yeah.
Where they care to do so.
Right. And made the point of, I think, I said this to the jury of like, listen, anybody who's been in this community very long knows, there are these two Savannahs, and they don't care about us. They don't want us to get office space down there. They just want to put up more hotels. They don't care about us, our area where we walk. They just want to have the tourists come in, have those tourist dollars. And every one of those jurors was nodding along like, you are right. And that was how we decided to try the case, because it's a difficult case in liability normally, but there's a sentiment in Savannah by the locals that, the tourists are definitely what matters to the government, not us.
How long had that curb been broken and pushed out, jutting out into the road?
Well, years and years and years.
That was another one of our things.
Right.
That was.
But you have some evidence of that, right?
Yeah, it was since 2007. We had a photo. That was the earliest photo on Google Street View that we could get. Showed this curb had already started pushing out in 2007, and the first witness that we called, Richard Spivey, who was the former street maintenance administrator, came in and took a look at that, and just demonstrated, admitted that had started then. The push out had started then. You could see it was already canting outward into the place where people expect to push their feet. And then you look at it in 2014, still like that, and even worse in 2022. It's worse. Still haven't fixed it. I mean, you go out there today, and it still is an awful
kind
curb.
of hard for them to say, well, we just didn't know about this curb.
They couldn't say. I mean, they had to say that it wasn't worth fixing because, they couldn't say they didn't know about it. So it's been there forever. And then we had evidence that somebody had been to fix. The way a city is supposed to have knowledge is either enough time went by to where you'd expect them to find it, or one of their employees had been in that area and had opportunity to recognize it. And we had two of those that were employees. We had one come in 2010 who fixed a pothole right by it.
That was the defense's exhibit.
That was the defense's exhibit. And then the other one was 6 months before the fall. They sent out a crew to paint this curb yellow. It's this no parking unloading area. They painted it yellow, and you could tell that they had recently painted it because the photograph we had from Google Street Views shows this broken curb, and like the broken part where the curbs have broken apart, the side, they had painted that yellow. So it's like, so you knew this thing was awful. And then they basically said, Well, it's up to the guys painting it to recognize it as a safety hazard. I mean, the city's got traffic engineers, engineers of all type, people who know what safety is, but they've got, this kid who's, good guy, he's working.
Yeah, hard worker, doing his job.
But he is not a safety expert and not the person anybody would think that a city the size of Savannah would have judging whether something's safe or not safe. So they didn't have any policy on it. Then they also have this 311 system, which is they expect residents to report problems. And if the residents don't report a problem, then they can kind of see no evil, hear no evil.
Right.
Well, they tried to say, well, we never had any 311 on any of this. And then Paul asked, well, what about this case? You had to give them an ante-litem notice, which basically give the government a notice you're going to make a claim against them. And that had happened, 10 years ago, and that's still not in 311.
No, they had that. Then they looked at it and said, there's not enough information just to figure that out. And it's like, well, you got a safety issue that hurt one of your residents. Did you follow up? Well, I don't think so.
Right.
And then, it's still not in 311, and we're in the middle of trial. So it's like, 311 really isn't a good system to know what's happening and whether somebody else fell on this curb.
All right, so let me go to the other side of what we have to show to get a verdict. Damages. What was the biggest hurdle, the biggest challenge y'all had in proving damages in this case?
By far, and this is probably the hardest case I've ever had for this, is figuring out what damages were related to the injuries from the fall. Because like we talked about, she had a very complicated medical history. She had a lot of things happen to her before this fall. And just to start, the law says that you take the plaintiff as you find them. Just because somebody's got a lot of issues doesn't mean you can say, well, if this person had been totally healthy, it wouldn't be as bad. You don't get to choose your victims is kind of the concept. And so we had to prove that everything, the injuries we were claiming were either caused by or aggravated by the fall. And that's what the law says. And so, she's already treating for a foot injury. She's already treating for a back injury. She's got a history of these things. She'd had a hip surgery. She was having a hip replacement. She's got a knee surgery. She had previously had this vertigo 12 years earlier. And so it's like, man, how do we figure this out? And I'll tell you what we did in this case that, one of the lessons I think is for any lawyers listening, especially young lawyers, is case selection. This was too hard of a case to accept, I think, for most people. And it's not a case we probably would have normally accepted for all these problems. And it's not to say it wasn't worthy, but it's a very difficult case. We decided we've got a few big trials coming up this summer, and we decided to work it up and put the resources into it for a larger, more complicated trial. And to be a zealous advocate, you don't have to do that. You can put the resources into a trial that are appropriate for the facts of your case. Well, what we did is we put two very experienced paralegals on it, but most importantly, we have an in-house nurse who helps a lot of times with our medical malpractice cases, but we got her to go through the medical records, summarize everything, and give us these theories on what's related, what's not, and what do the medical records show to prove that. And she did a wonderful job of figuring that out. And it's stuff that we as lawyers wouldn't be able to figure it out without the medical help. And so we were able to take that and that theory and go to depose the doctors, show the doctors the records, their own records and other doctors' records, and after explaining that to them, ask them what's related and what's not. And it became clear that there were separate injuries that occurred. Like the previous injury for her foot, the plantar fasciitis, was a different injury than the torn ligament she had. But the torn ligament and immobilizing the leg to deal with it made the plantar fasciitis worse. So it aggravated that condition. And then with the back, she already had the back injury, but the pain she was having was what's called radicular pain. So she had back pain with pain going down her leg. The pain we were claiming is back pain going down her leg. But the key is it was a different nerve. The nerve that she was already treating for, and I forget the name of it, but it's no, that was that's a foot nerve. Y'all are better with the names of the medical stuff than I am. But
sciatic nerve?
No, that's the one that
it's the front right femoral. Femoral.
So it goes over her hip and down the front side of her leg, and that's the pain she had been reporting. The pain that developed after, and that's because she was in this lopsided boot, was from L5, S1, lower back, that was the sciatic nerve. And that goes down, that's pain that goes down the back of your leg. So we were able to get her pain management doctor to explain the different nerves and say, yes, this was a new injury. and showed him the records from the foot doctor of this boot she was in and said, oh, yes, this would have caused that sciatic pain that's going down her leg. And that's what I was treating her for because the other pain went away. And so that was really tricky to do. And like Steven said, it was really boring because you got to just walk through all these records with these doctors. It's on videotape, and they turn off
Two
the lights.
binders, 8-10 inches thick of records.
Medical records.
Yeah.
And we zipped through it best we could. I mean, one was an hour, one was like an hour and a half. But, they turn off some of the lights in the courtroom. Jury's falling asleep because it's not exciting stuff. So the way we handled that is in final close, I took clips from the videos of the doctors that really got down to not the walking through all the little details in the records, but the final opinions, and said, this is what the doctor said about this, and played the clip. This is what the doctor said about this, and played the clip. And
I thought that was very effective.
Totally agree.
In fact, I thought it was so effective that, our baseline position has always been if we can get a doctor to come live to trial, we would rather do that. But in a complicated medical case, doing it by videotape and then being able to play those clips at closing is really valuable. And we may want to reconsider that. We may rather have them on videotape so that we can do just that at closing going forward.
I agree because it's so mind-numbing to hear this stuff, and you got to do it for the record. And for those who aren't lawyers, I mean, you can't. We talked to a juror afterwards, like, I wish you just played the clips during the trial, and I said, we can't do it. We've got to establish the basis of these opinions. You can't just, or else they're not going to be valid.
Well, let me ask you this: $700,000 verdict. How much were the medical bills?
$110,000, and again, we had to be very precise to make sure that the medical bills were all related. And we erred on the side of caution. Like the first time she saw the foot doctor was 2 days after the fall. Well, she already had an appointment that day for plantar fasciitis. So we told him, we're not asking for that. She didn't make that appointment for the new injury. She talked about it. She was treated for it, but we're not asking for that. We're just going to do the ones that are very clearly related because it's such a complicated issue. We didn't want to have any gray area and seem like we were overreaching.
Was there ever an opportunity to settle this case before trial?
I mean, there was discussion, but the
we mediated, technically.
Yeah, the city offered $50,000.
Okay. And that just was never going to get it done.
Well, there were medical liens that had to be paid back. In other words, she had insurance that paid for her medical treatment, but they want to be paid back a full amount, and by law they had an ability to do that, and the amount they need to be paid back was more than $50,000. So why would she do that if she wasn't going to get $1 in her pocket? It's not worth it. And so we really didn't have any real opportunity to settle the case.
Yeah, we were never going to get to a point. I mean, some liens are more flexible than others, and there's a doctrine in Georgia, the made whole doctrine. Basically, if you get hurt, somebody hurts you, and then you have medical bills as a result, and the medical insurer may have the subrogation right. If the amount you recover doesn't make you whole for your injury, your entire injury, then that subrogation right can't be enforced. Some liens are subject to made whole, some liens are not. This particular one was not. It was very good. So it would have been, she was basically upside down in the case in terms of what the city was willing to put on the table.
And the ones that are not subject to made whole are typically insurance plans that are provided pursuant to ERISA, which is a federal law, which preempts the state made whole doctrine.
Yeah, exactly.
Okay. Well, guys, good job. I know it was a tough trial, but y'all got a great result. Spent an intense 3 days at the courthouse, and congratulations.
Before we go, any trial stories? This is all kind of the nuts and bolts. Anything of the TV type moments that might have happened there that stuck out at you? That's always the more fun stuff.
Other than the bailiff trying to ask our paralegal out.
Yeah, that was a little awkward.
Yeah, both inside trial and outside trial. There's always some stories. Paul mentioned one, so I want the one when the city's lawyer asked about the hotel being there. I mean, my jaw dropped that was the question because that was our whole point. Another one that comes to mind with me is Jerry, Mr. Jones was the guy that painted the curb yellow, and I got to call him on cross because he was an adverse witness. He was the city's employee, so we called him to testify for us. But since it was adversarial, I got to do it in a cross-examination format and asking him about what a defective curb, an unsafe curb is. And So I crossed some of that, and his lawyer came up and asked him, how do you know? And he's like, basically, you know it when you see it, right? And that was another moment. It was just like, that you know it when you see it. That's the standard we're going to have here in the city of Savannah. So that was one. The things that really that for this particular trial, I think watching the juries and just their engagement in the process and their reaction to some of these things and watching it just kind of show, it's just a really cool thing. You can never really know what they're thinking, but it's neat to watch body language, see how they react to that, and understand, that like they're following along and paying attention, and seeing that in action is just a really cool thing. And the last thing I'll say is this was kind of an old school tort case, and it was in the old Chatham County Courthouse. They're about to this may be one of the last civil trials in that old courthouse. I got sworn in that courthouse, and I know that Paul, I believe you got sworn in that courthouse. Andrew, I assume you got sworn in that courthouse.
You were in the old courthouse that closed in the 70s.
I'm not that old.
While we were waiting on the jury to deliberate, I went up to the old law library, and I found this picture from the 1990 to 1991 Savannah Bar Association membership and presidents, and just found a bunch of old characters I knew, some old judges, some who've passed away, and old lawyers. And the secretary of at that time was Malcolm McKenzie, who was the defense lawyer. And so I got to go take it down there, and Paul's dad was on there. And so it just felt really historic, and trying a case against, Mr. McKenzie, who's just a storied Savannah trial lawyer on the defense side. And I got to cross-examine Dr. Clark Daraso, who's just, he's a defense lawyer. That was a really cool, just like way. And this old, trip and fall case about the city of Savannah, Paul talked about the themes. I mean, as a resident, you feel that. And so it's a little cathartic for me to be able to try the case against the city for taking care of the tourists and not the residents. So yeah, it was some pretty cool stuff.
Awesome. What about you, Paul?
Mine was, I don't think I've ever had this happen before, but the only witness that the city put up for liability was their risk manager. Now, and I thought about it the night before, and I was like, what does a risk manager have anything to do with what a curb is safe or not safe? A risk manager's job is to keep the city from paying money. I mean, that's the whole thing, is keep claims
He's basically,
down.
although there's not insurance, he's the insurance adjuster for the city.
Yeah, he's trying to save the city money. And so I went up there to start it's like, I'm really confused while you're here to testify. It's like, your job's this, and it's like, your job is essentially to save the city money on claims like this, right? And he's like, yes. And said, well, if there was a big, if the jury made a substantial verdict in this case in favor of Miss Collier, I mean, it would be bad on your job performance, right? And it was like, well, yeah. So,
I mean, it's
basically like
that was.
So he
cool
admitted
moment.
that he was professionally biased on it because it was against his job performance. But the good thing about that, I think he's a pretty good guy. I liked him, yeah. But he then answered the questions very honestly and established a lot of things for us that they had up until that point really been denying, and established that we expect people to drop people off there. Yes, we expect people to walk there. Yes, this is I don't know why it was painted yellow, but it is a drop off zone. Yes, it looks different from the hotels.
Yeah,
kind of stuff.
Being
so
an honest witness on cross.
Yeah.
I mean,
a lot of respect
kudos.
for him for answering
Totally.
honestly.
I mean, a lot of respect for Brian on being just an honest witness up there, and doing his job, but not being too squirrely.
And the last thing I'll say is something I tried for the first time, but I'll do this again with a complicated medical case, is the idea of this whole eggshell plaintiff, you take the plaintiff as you find them, is so complicated for people.
Yeah, you've got all these conditions that you come into it with.
And it's like, it just gets confusing. So what I did is I bought a Jenga game, and I put it up on the table kind of in front of the jury and started off like, you take the plaintiffs as they find them. So how they find her, and they have diabetes, this back condition, yada, 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 and took a block out for each one of those. And then as we went through the clips for the doctors, saying everything was related, I started taking out additional blocks. And by the end of it, the last thing was her future treatment. She had one future treatment that she was hoping to get. And I said, the problem with this is, and she has since in the last year or so had a stroke. It's like if she's medically able, but the problem with all this and this continuing issue is, you have one more surgery, then I took out a block, and really without forcing it, the whole thing fell down. So I just didn't say anything.
Everyone was watching with bated breath, like, when is that thing going to fall? And it was very effective and engaging.
It sort of simplified it and got some attention. So I like that. If any lawyers out there, that's a pretty, That wound up being an effective way.
It worked.
Yeah.
You didn't practice, Paul.
Well, I left it in court. We thought we were going to close the day before, and I forgot it in the courtroom. So I was planning on testing it out at home to make sure I knew how many blocks I could get out so it didn't fall halfway through. But I got pretty lucky. So if you're going to do that, I would suggest maybe practicing a time or two. Oh, and make sure that you are comfortable enough in front of a jury that your hands don't shake. Because I went to get the first block, and I thought, oh, man, I hope my hands don't shake. And fortunately, they don't. But something to know about yourself.
All right. Good job, guys.
Good stuff.
Thank you. All right.
Thanks, Andrew. Dad joke?
Yeah.
I got one.
All right.
And it came from the trial. So a deputy, taking his job very seriously, making sure the courtroom was secure and safe. Getting everybody out of there, and we went out for lunch and came back, and the door was open. So our paralegal came in to start getting things set up, and he came back in, and he was very flustered, very frustrated that the courtroom had not been totally secured. And it turned out that he said the door was ajar. And I was so confused because I could have sworn it was a door, not a jar.
That's terrible.
That really is bad, even for dad jokes. All right, guys. Thank you for listening.
Thanks for listening to Justice for Y'all, hosted by the attorneys here at Bowen Painter Trial Lawyers in Savannah, Georgia. If today's episode resonated with you, or if you find yourself needing legal guidance, remember, we're just a call away. You don't have to work through the difficulties of your situation alone. Visit our website at bowenpainter.com, that's BOWENPAINTER.com, or give us a call at 912-335-1909. We're here to serve you with the dedication and warmth only true Southern hospitality can offer. Thanks for tuning in, and don't forget to subscribe to our podcast on your favorite platform so you don't miss an episode. And tell your friends and family about us if they're ever in need of some legal insight. Take care, and remember that at Bowen Painter Trial Lawyers, we're committed to justice for y'all.